It's Lisa from Been There, Got Out. And today's guest is an Instagram Live virgin. We love them. Her name is Marian Grande, and she's from a company called Absolute Dispute Resolution in Ontario, Canada. Let me see if she's here yet. Yep, she is. Okay, so Marian, I'm inviting. I see there's a request to be in. Let's see if this works. Um, so she's a parenting coordinator, among other things. Yay! Okay, hi, Marian.
Hi, how are you?
Good. Okay, so I was just saying that we recently met and you wear a few hats, but your company is called Absolute Dispute Resolution. Our community is dealing with serious disputes because we are a community of, unfortunately, high conflict divorce and post judgment people who are constantly being dragged back to court, where the other side is unfortunately trying to wear us down and bleed us dry financially. So I love finding professionals who can hopefully put a fence around what we call legal abuse and keep our people out of court, where they keep more power and have more choice, and meet people like you who can help them do that and save time and money and energy and hopefully protect their children as best as possible, rather than leaving it up to strangers, because nobody likes that. So before we get into it, can you first introduce yourself and talk a tiny bit about who you are and what you do, what your roles are?
Absolutely. Thank you for having me on today. So, I am an accredited family mediator, parenting coordinator, and divorce coach. I am based out of Canada, Ontario to be specific. And I have over 20 years of family experience dealing with separation and divorce at the court level. I've worked with counsel, and now I work strictly with clients and keeping them outside of the vicious court cycle. And we either try and mediate, or if they already have a parenting plan or a separation agreement, then I will step in and fill the role as parenting coordinator.
Okay, so now mediation, we strongly believe in attempting mediation, but a lot of times people say mediation is never going to work with my ex. What do you have to say about that? Because you do deal with conflict.
Yeah, like I have high conflict cases and I have no conflict cases. So you really can't say it won't work unless we get in there. I've had high conflict cases where parties swore it would never work, and it's turned out to be great. We were able to settle. I would probably say at least 95% of my cases settle outside of court,
Yeah.
which is quite high, and people don't realize that. And I think that people don't even realize that mediation is an option or a first step. But I'm not sure how it is in the US, but in Canada, lawyers actually have a duty of care to recommend mediation in family law matters in accordance with the Divorce Act. So I think there needs to be greater knowledge, and people need to educate themselves on how mediation can assist them. And it's not a blanket band-aid cover all kind of situation, right? But like I said, a high percentage of my cases settle outside of court, and
Yeah.
the ones that don't, sometimes they settle for part of the issues, and then part of the issues end up in court. So that being said, you really don't know. And really, anyways, here in Canada, it is your first step. And a lot of times, what happens is if people bypass that first step and go to a case conference, that's the first appearance in court here. It's called a case conference. A lot of times, the judge will actually send the clients back to mediation because
Same. Same
yeah,
here and in a lot of other parts of the world.
yeah. So, and I think that's, people don't realize that, and they're spending money to get to that first appearance, and then they're being told to go to mediation anyways. Whereas if you've gone to mediation and it hasn't worked for whatever reason, then your next step would be court. And then at that point, you're in a better position to let the judge know that, hey, you know what, I've tried mediation, it didn't work for these reasons, and that's why I'm here, instead of wasting all that money to get to that first appearance only to be told to go to mediation.
Yeah,
Yeah.
exactly. I'm thinking I just put a post up this morning because I feel like from what we've experienced and learned and the experience of our clients that even if you have, let's say, a couple where the one side is high conflict, if you have the right professionals involved, it doesn't mean it has to become a high conflict case. If you have people who can manage that personality well, then you have a much better chance of resolution, especially outside of court. But it's a matter of finding professionals who know how to deal with that. The court does not.
No, no, the court does not. And it becomes really this vicious cycle where you end up in this court system for years on end. I have clients who have been in court for over 10 years,
Mm-hmm.
and
Us too.
it's just a money pit. And at the end of the day, you have no say in the outcome. Whereas in mediation, you at least have a say. Um, but in court, one person is not going to be happy.
Yeah,
One, there's
we
always
just
going
were.
to be a winner or a loser, right? That's just how the court system is set up.
Yeah, yeah, or both people are going to be unhappy.
Exactly. Yeah. Yeah.
Yeah. We were just talking with a client earlier today about she's very early in the process and she is dealing with a difficult personality on the other side, and nothing has really happened yet except lots of threats. And so the lawyer wants to immediately start filing motions for financial discovery, but she knows her ex, like money is a trigger. And I was like, have you ever thought about negotiating before you turn on what I call those financial spigots and put your ex on the defense? Like, she's got a lot of leverage because they've been together for nearly 20 years of like knowing the things that matter to him, the things that matter to you, the things that sort of everyone cares about in terms of the court's values. For example, like the health and safety of the children and the relationship with the parents. Like, I bet there's a lot you can do in negotiation before you start filing lots of motions, which are just going to explode in court. And she was like, I didn't know that you could do that. I thought you should that you're just supposed to start filing motions. And I was like, there's actually a lot of things you can do beforehand, before,
Hmm.
so you don't start wasting all that time and money and energy. The court should be like, if there's no avoiding it. I mean, certainly when you need to get support and certain orders enforced at the beginning, that's something, but that's not the case with that particular situation. This person is still being paid support. They're not being left penniless, even though it is a high conflict case. But I was like, this is such a great opportunity. And I was thinking about our conversation today because I'm like, you need to watch this.
Yeah. No, absolutely. And again, going back to these misconceptions, people are so used to thinking that court is the only way. As soon as they get separated, contact a lawyer. That's the only way. And it's really not. And those motions, you're going to be stuck in, again, back to this vicious cycle. You're going to be stuck in that loop of motion after motion. You're spending money. You're going to run out of money eventually. And even if you have endless supply of money, it's just such a waste. That money could be put to so much better use than fighting your ex in court.
Right. And also, then when you start doing that, not that it might not come to that, but you are on the court's calendar and the courts are completely backed up, especially with COVID. So you have to keep waiting. I know for me, with one of the motions, and I'm certainly way post judgment, and now it's been a couple of years since this happened, but to get one court appearance, it took 15 months. And then the judge had a problem, was like, we need to redo this hearing. And I had to wait another year. So it was like
Yeah.
2.25 years to get one court
Yeah.
appearance on
Yeah.
something. I
Yeah.
was just like, I can't. How do other people function?
Yeah, like even here in Canada, the wait is ridiculous for court. Unless it's an emergency motion and it involves, children and maybe a flight risk, or the kids are, in harm's way. Those types of things. You're waiting a long time. Like trial, you're waiting at least 2 years to get to a trial. So you have to
Yeah,
be prepared to deal with your ex and all those outstanding issues during that time.
right.
And that's the challenge, right? That weight. Whereas like in mediation, if you can settle it in mediation, you're in and out. Mediation won't run you more than a year, and even a year is pushing it. I mean, I've had some high conflict cases where, you know, we were maybe 18 months at most, but we ended up settling and, you know, thank goodness. But you would have still been waiting. Nothing would be resolved in court
That's
by that
a
time.
short, yeah, that's a
Yeah.
short amount of time for our community, like a year and a half to get something done, like
Yeah.
a divorce finalized. That's a short amount of time. I
Yeah.
mean, the other complaint that we hear all the time is people saying, I'm 40,000 in and we haven't even gone to court yet. We haven't even had an
Yeah.
appearance. It's just this paperwork and I can't understand. They're so angry and confused and frustrated and despairing because they're like, I can't afford to keep going when nothing's happened yet.
Yeah.
There's
Yeah.
this
Yeah. That,
sense of paralysis.
yeah, I hear that complaint often as well. You know, I've spent this amount of money and they've done absolutely nothing. And it's not necessarily that the lawyers have done nothing, it's that it's people think that for that amount of money, everything should be done. And
Right.
that's just not the way the system works, unfortunately. So when someone's saying, "Oh, I've already spent 40,000 and nothing's been done," well, maybe there's been some disclosure done. Maybe there's been phone calls back and forth and emails, and depending on the hourly rate, that's going to add up very, very quickly, and people don't realize it. And you know, it's when I say you need to go through your invoice and actually see the work that's been done. Work has been done, but it's an expensive process. And probably within that time, like you would never spend 40,000 on mediation.
Right.
I like
Right. Right.
right, like I've never seen that. And when I talk to my clients or, you know, anyone who's inquiring about our services, I always tell them you have to be prepared on the low end to spend at least 60,000 if you're retaining counsel and you're going to end up in court. 60,000, and that's a drop in the bucket.
Yes.
That is such a
Yeah.
drop in the bucket. Like you're not going to be anywhere with that.
Yeah. And, you know, I think I told you, Marian, we've done a series with a Canadian lawyer who actually wrote the foreword to our book named David Morneau called The Client as Consumer. And that a lot of us come out of these difficult relationships and we're really vulnerable targets. And we don't do the research. We don't realize like there are options to getting away from this person.
Yeah,
So maybe it's worth investigating, you know, certainly speak to a lawyer. Absolutely. Like you're going to need a
100%.
lawyer,
Yes.
but 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 there's other ways. There's amicable divorce, there's collaborative divorce, there's mediation, there's people who want to keep you out of court to save you that time and money and keep as much power in your hands. And you know, we deal with 100% domestic violence and we still firmly believe that that option should be on the table for people trying to get out of these relationships, because there's a lot you can do with professionals who know what they're doing, and there's a lot you can do with leverage and knowing what the other person values. Often it's money from the other side. Often from our side it's the kids, not always,
Yeah,
but it is, you know, it is something. Okay, so someone's saying collab is still expensive. FYI,
it
yeah, and
is.
I think divorce in general is expensive. Unfortunately, I don't know anybody, even amicable, where it's been, you know, less than a couple of thousand at least. It's just an
Yeah,
expensive process.
100%. And when I talk to my clients, I always say um, mediation's cheaper, but you're still going to be paying because you're getting separated. And that's just the way the world is, right? But it's at least on like at least 75% cheaper,
Yeah,
right?
and that's significant when we're talking about
Yeah.
thousands, and in our community, hundreds of thousands,
Hmm.
sometimes millions of dollars being spent on litigation
Yeah.
that goes on for years and years and years, and it's just this spinning, spinning, spinning thing.
Yeah. And once you're in the court system, and I have clients who I do parent coordination for, and most times they're still within the court system, and they're just so over it. They're so done with it
Mhm.
that at the end of the day, a lot of my clients just say, "Whatever, I don't care anymore. Just take it. I don't care. I'm not going to fight anymore." But by the time they've realized that, they're years in with the court and hundreds of thousands of dollars have already been spent. So it was all for nothing.
Yeah.
So I'm of the strong opinion that we should get into mediation. Let's negotiate. Even if you don't get 100% what you want, and let's say you did get 100% of what you want with the court, how much did it cost you to get that 100%? So at the end of the day, you're not getting the 100% that you think you are, because you have to offset that with what your legal fees were, your mental health, time off work because you're going to have multiple court appearances, multiple motions, also the mental health of your kids if you have kids involved. So you're not really getting that 100%. And in a perfect world, let's say you did win 100%, which is extremely rare that you would win like 100% of everything. You just spent that 100% to get there. So at the end, you've either broken even or you're at a loss, and you could have settled that years in advance with mediation, and you probably would have been much further ahead financially.
Yeah, and there's a label for that. We call it the cost benefit analysis, and how important it is to continue doing a cost benefit analysis. Like, what am I doing? What am I hoping to gain? What could I realistically gain? And how much is it costing me, not just with legal fees, but other fees? And again, that mental health thing, time off work, and the energy. Also, your physical health deteriorates during stuff like this. I mean, I had insomnia for years dealing with court stuff.
Yeah.
It really has an impact. And what you were saying about getting 100%, I mean, yeah, we don't know anyone who gets 100% because it's an awful, there's a grieving process even when it's a bad relationship. It's not like a winning thing to get out of something that you really invested a lot into.
Yeah.
But one of our clients recently had a lawyer going through the divorce process, and they weren't getting very far, had invested thousands and thousands of dollars. It's over a year, and was trying to settle some last minute things, financials, and the parenting plan was luckily already done. And the lawyer said it's going to cost, for 2 days of trial, it's going to cost $48,000. And sent I loved it that we could actually take a look at it, like a breakdown of all of the hours and who would be doing what, that would add up to $48,000 for two days of trial. So luckily our client learned this ahead of time and could make the very intelligent decision, this is not going to work. So we ended up working together and doing negotiation outside of court, and the client got more than they even thought they would get. Not 100%, but better than they thought by doing it themselves, in a negotiation setting, not even mediation, just negotiating. That person negotiated with the other side, counsel, had a lot of leverage, and it's done. And I am so happy that this happened. And the client is amazed.
Yeah. No, those are great stories, because
Yeah.
you know, people realize the system, and really I don't know anyone where the system benefits them.
Yeah.
Like, I really don't know. I have a quote on my website, and it basically says that when you're in court, nobody walks out healthier, happier, or wealthier. And
That's a
it's
great
true.
quote.
Yeah, and it's true. If you're in the court system, you are not going to be happy with the outcome. You just are not.
Yeah. Can you talk about parenting coordinators? Because that's a big part of our world. Often when our clients do a parenting plan, and my partner Chris writes parallel or high conflict parenting plans, we want to have some guardrail in there, because we know somebody's going to have to go back to court. And so we don't want to go right to litigation. So often we'll say, put something in there, like before somebody can file a motion, go right to court, that you try mediation and or a parenting coordinator. So tell us what a parenting coordinator is.
So basically, once a parenting plan is in place, right? It's just like you said, there's usually a provision in the parenting plan that before it can be brought back to court, like in our agreements, we always have a dispute resolution clause. And it speaks to a parenting coordinator, who is your go-between between the two parties who are disputing. So maybe something in the parenting plan that they don't agree with, and maybe, let's say, like schooling.
Right.
Let's talk about education,
Right.
right?
Because that's one of the
Um,
major decisions, education.
yeah, so that's one of them. and let's say one party wants the child to attend one school and the other party says, no, I want another school. So now they're at an impasse. So they would come to somebody like me, who's a parenting coordinator. We would mediate on that issue. If through mediation it's still not resolved, then I would arbitrate on that issue. And basically, the decision would be up to the arbitrator, and that's what it would be. It's almost like a mini trial. You both have an opportunity to present your cases, present your evidence, and then the arbitrator will make the final determination and put together an award. And then the parties, if they're not happy with that, they would have to appeal that through the court. But at least that's there. You know what I mean?
Yeah.
Like if
Okay.
you were to bring that matter to court.
Slow that down, because that is huge,
Yeah.
huge.
So
And I want to, because where we are, and in a lot of other parts of the world, you get a parenting coordinator called a PC, and often, and in some states, you can't have a parenting coordinator with decision-making abilities. A parenting coordinator most of the time is there to almost like a mediator, but just between the two, where it's like over a very specific thing, like you said,
yeah.
school, and then they can only, listen, but they can't say, well, this is a decision. But you're talking about a whole new
Yeah.
level, unless it's a parenting coordinator, decision maker. And I know we interviewed someone in Pennsylvania where she's like, we're not allowed to make a decision. But you're talking about the title of our talk today, like what to do when you're at an impasse and you want to avoid going to court.
Yeah.
I think we need to talk a lot about that option of arbitration, because Marian, I told you just yesterday, one of our clients has been dealing with an issue regarding trying to get a little boy some therapy for some aggressive behavior. The other side doesn't want it, doesn't think it's a problem. She thinks it's a big problem. And they've been talking about it with a parenting coordinator, but nothing has happened. And so she's at the point where she's like, I have to go back to court. And I told her about this interview, and she mentioned to the parenting coordinator, look, we're at an impasse. Like, this is really significant. Things are getting worse with our son. Like, what am I supposed to do? And the parenting coordinator said, let's do arbitration. I was like, oh, wow. So
That's
can you
awesome.
please go into like detail, like, like slow it down for this part, because a lot of people have no idea. Maybe a little more in Canada, they know. We have Canadian clients, but especially for our American clients and those in the rest of the world, we always think about arbitration with like businesses, but what happens with a parenting coordinator versus arbitration? Because the parenting coordinator doesn't stay in that same role, right? It's a different thing with the arbitration.
No, the parenting coordinator would arbitrate.
Okay,
So
so tell us what's the difference of arbitration versus just parenting coordinating.
yeah, so parenting coordinator, it's like you said, there's a specific issue, right? So the parenting coordinator will first make sure that they have jurisdiction over that matter, right? To mediate on that matter. And then once the parties agree, yes, then it goes into basically, I call it a PC session.
Okay.
But it's basically mediation on that one issue, where there's a dispute either in the parenting plan or a parenting issue. If they both agree, right, they want to go to the PC. So then it goes through mediation, and if it can't be resolved through mediation, then the PC will arbitrate on the matter. I think there are PCs who don't have who don't arbitrate. Basically, they aren't accredited to do that, I think. In my case, I do the PC, and then if we can't agree, I'll arbitrate on the matter. So, giving both sides the opportunity to present evidence. I'll give them a timeline, like you need to present evidence by this date so I can review it, and then we'll have a session, but it's arbitration at this point because the mediation didn't work. And then as the arbitrator, a final decision will be made. So let's talk about
Okay,
the
we pause for
example.
1 second. Pause for
Yeah,
one more second. Sorry to interrupt you, Mary, but
that's okay.
I'm just thinking about our particular client. So when you say, okay, when mediation doesn't work, and that's where most of our clients are at, and they have the parenting coordinator, you said each side has the opportunity to present evidence. This does not involve their attorneys. This is the parent themselves that is presenting evidence, right? So it's almost like each party is self-representing why I want this for our child.
Yes.
Okay.
Yes.
So that's a big difference
Yes.
than having your lawyer get involved. So it's on you to
Yes.
understand how to communicate effectively
Yeah.
to a parenting coordinator about here's the issues, here's the history, here's why it's so important that I need this. And
And
you're just up against your ex, and the parent and the arbiter is like the judge.
yes, I'm sure there are cases where you can bring your lawyer to arbitration. In my cases, nobody has, because now they're paying for arbitration and now they're paying for the lawyer to be there too, which kind of defeats the purpose, right? And it's the same with mediation, where I have clients who bring their lawyer, but the majority don't, because the whole point, or one of the points of mediation, is that you're saving money,
Right.
right?
Right.
So now if you have to pay for counsel and you're paying for your mediator, now it's expensive,
It's like
right?
double.
Yes.
Well, the
Yeah.
mediator and lawyer, yeah, and then it's you taking away from work and everything
Yeah.
else.
So, so basically, most of my clients, when we do arbitration, it's just the parties involved. So let's talk about the case where there's a mental health issue and the mom wants medical care for the child, and the dad doesn't, right?
Right.
Like,
Hmm.
talking about your situation. So basically, the mom would present her case on why, right? Here, if they've already gotten an assessment for mental health, right?
Hmm.
The mom would present that, or any conversations with doctors, any
And
correspondence, or
what about like school, like things with school? Like there's been incidents at school where the kid has like hit other kids or bitten
yes,
other kids. So
yeah,
all of that counts as evidence.
yes. So all of that counts. And then let's say the dad in this case would present evidence on why he feels this isn't an issue. So what evidence could the dad provide? I'm not really sure. Maybe
He
teachers.
he doesn't have the money. He says he doesn't have the money to pay for it.
Oh, okay. So that's the issue.
Yeah.
The issue is money, right?
Well, that's
Pardon?
yeah. That's
Yeah,
the
yeah.
issue.
And
Right.
and the thing is, we always look at the best interests of the child,
Right. And that
right?
is important to address here, that even though it's not a judge, and it's an arbiter or a mediator, you still are like almost like an officer of the court. You still have the same values of the court, and that's the
Yes,
best interest of the child.
exactly. So if you're saying it's an issue of I can't afford medical care, right? And things are different in the US. Like in Canada, well, in Ontario we have OHIP, right? So the government pays for health care. There's certain things that the government doesn't pay for. Like if you want a professional assessment for, let's say, ADHD, it's not covered by the government.
Hmm.
But you could go to your doctor, and uh, they can prescribe certain things for mental health. So you have some support, way more, I think,
Yeah, yeah, that's
than
definitely
you would have.
different.
Yeah. So it's different. And but if we're just talking about like a straight case, there's no
Yeah,
uh, government assistance for any kind of medical care, and now one of the parents can't pay for it. Well,
can't or doesn't want to for whatever reason.
exactly. So as the arbitrator, you would have to look at both sides, right, before making a determination, looking at what really is in the best interest of the child, right?
Yeah. Yeah, I'm also wondering in situations like these where someone's saying, I don't want to pay or I can't pay, and it's clear that a child does need medical assistance. In your experience, and I know it's different, you can't say for all, but like, what if that same parent who's trying to get the child medical help and offers to pay and says, I also need to have tie-breaking authority because this happens all the time where our child needs medical assistance and the other side say they don't have money, like, does that tend to equate to more you know, decision making power? If someone's just like, I'm not doing it, I can't do it, I can't do it. And the other side's like, I can do it, I can do it. Like, we can still talk about it and I'll pay for it, but we need this care for the child.
Yeah. So I mean, you can do. So I'm not sure how it is in the US. In Canada, we have decision making responsibility. So it
Okay.
covers things like healthcare, for instance,
Mhm.
education, things like that.
Yeah.
So it's either joint or shared, or,
Right.
or one person has sole decision
Yep.
making,
Same.
right? Or there's decision making that's joint, except on one issue, maybe health. So even though, and the other thing actually could be also, you could have sole decision making in consultation with the other. So,
Yeah.
you
Yeah.
as the
That's what
person,
we have.
yeah, so you have sole, I have the final say, but
Right.
here I'm consulting with you saying that our child needs this type of care. And if the other person agrees, great. If the other person doesn't, then that person has the final say.
Right.
So, right. So there's a few ways, kind of workarounds, let's say, for that. But
Yeah.
if one person is saying, listen, I can afford it, I have the time to take them back and forth to appointments or to deal with this.
Yeah.
But because we have joint decision making, I need your okay on it,
Right.
right?
That's the
Yeah.
situation here. The
So,
joint decision is what's holding up the child's ability to get care because one parent is refusing, even though the other parent is capable of taking them to appointments, paying for it, etc.
yeah,
But it's like, it's a power, we believe it's a power
yeah.
play.
And oftentimes it really is. But I think that, yeah, in this type of case, right, I can only say so much because I don't know all the
Right.
particulars of it.
Right.
But
Right. I know.
yeah, but I think, right, if you have one parent who's saying, I can deal with it all, including the financial, really, what reason do you have for withholding this care from the child? Like, what is the legitimate reason? What evidence are you going to present to an arbitrator to support your position? I don't know that you have one, because the other person's paying for it. So that's not your position. I can't afford
Right.
it.
Right.
You can't say, I don't have the time,
Right.
because the other person said they would undertake all that. So really, I don't know what your position would be. What would you present to an arbitrator to make them see that the child does not need care more than the child needs care, while still keeping in mind we're looking at the best interest of the child?
Mm-hmm.
So even a parent saying, I can't afford it or I don't have the time, to me isn't a good enough reason,
Mm-hmm. All right. That's super
right?
helpful.
Because it's
Yeah.
not in the
It's
best interest of the
logical.
child. We're
Right.
talking about you. And maybe this year you shouldn't, I don't know, play golf, right? And maybe put that money towards the child. That is where, like, there's also the issue of priorities, right? But in this case, the other person's paying anyway, so I don't know what evidence the the dad would provide to support his position.
Right.
You can't just go to an arbitrator and say, no, just because I don't want to.
Right.
Like,
Right. Well, yeah. Well, unfortunately, that's what a lot of our
right?
clients deal with in general. Is the other side just says they don't have like
Yeah.
a objection with merit. It's sort of this like, well, you want this for our kid. Well, no, I don't. I don't want it.
Yeah.
So,
Yeah.
okay. So let's talk a bit about the calendar of like arbitration. So we already talked about court calendars taking, a year to 2 years sometimes to get a date unless there's some extraordinary emergency, and everyone feels like their case is an emergency, but
Mm-hmm.
an emergency is usually, very specific things, and often judges get angry when you file what we call an ex parte, and then it's like,
Yeah.
what? Get out of here. Like, that's not an issue for us. So if let's say I'm having this problem, it's school is coming up now in September. My kid
Mm-hmm.
is going to kindergarten, and I'm at an impasse. We're going to parent coordinators, our parenting coordinator, and my ex is saying no for the school that I want, and I want this school. Like, how soon could we actually expect to get it done if we go to
Yeah.
arbitration?
So first, you would first do it in mediation, right? So you would
Right.
probably do a couple of sessions trying to resolve it that way, right?
Mm-hmm.
And then, if it doesn't resolve through mediation, we would give a timeline in terms of, you need to have your evidence into the arbitrator to review at this by this date. So if it was, let's say, okay, so we're in July, September's coming up really fast. Basically, I would say if by the end of July we've mediated and we have not reached a resolution, by mid-August we need to figure something out. Like we need to have already been to arbitration, and a decision will have to be been
So
rendered.
it's weeks versus months and
Yeah,
years.
for sure, for sure. Depending on the issues, right, and how busy the arbitrator is. But with school being right around the corner, for me, that's an important issue that should take precedence over maybe different issues.
Yeah.
Let's say
Yeah.
extracurricular activities or something like that,
Right.
right?
Yeah. Yeah. I mean, what a breath of fresh air to think, wow, I might actually have the ability to get a decision that I could use soon rather than, I mean, for where I am, the judge has 120 days to make a decision. So 4 months, right? Yeah, 4 months.
Yeah.
And so many times, like I've been in court. I mean, luckily things really settled down a year ago, but being to court dozens of times, and every single time it would take months to get a decision. And that's why it took all of those years, because it was always waiting for a decision and then figuring out what to do next and then waiting for another court appearance
Yeah.
with status conferences in between. And then there's continuances. And that's what happens when you're in the legal system,
Hmm.
right? You really don't have control
You
over
don't.
that. So
No.
I love that this is like an alternative to that.
Yeah.
Now,
100%.
what about what about like any helpful tips to get through the process that people should know? Like when our client mentioned that this was a possibility, I said, I think you should present your evidence as if it's like a mini trial,
Yeah.
like focus on the stuff that, the best interest factors, and present what's happened, like from the most recent or most egregious to the past, to show the pattern of behavior and why you're asking for what you're asking for and why your son is entitled to it. Don't you, because the parenting coordinator said, oh, just send me a list of like your concerns, or tell me why you think you should get what it is that you're asking for. But I was like, no, I think it's probably a little more serious than that.
It
Like I
is.
wouldn't just list like five
Yeah.
sentences.
Yeah. You need to approach it as if you were in front of a judge. And I always say the
Okay.
same thing to my clients. It's a mini trial,
Yeah.
right? So it's a mini trial on that one issue that you've given the PC jurisdiction to deal with, right? And you need to take it very seriously. So you have to respect the timeline the arbitrator gives you. If there's a date book for arbitration, you must attend. Like there's certain rules. You have to take it very seriously, and you have to present your case and your evidence as you would in front of a judge, in my opinion.
How much time do people have to present their case? Because, a lot of people think, not our clients because they know better, but they're like, I've got binders of stuff and I'm going to come in and get into all this. Like, so can you correct that?
Yeah, no, 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 don't bring binders of stuff because you're going to be limited for time. Like it depends on how many issues, right? So I normally ask for your evidence in advance so I can review it. If there's a problem with it, I'll let you know. But like even speaking time, you're not going to be speaking for hours on end.
Mm-hmm. What's
Like
like the average amount of time for, let's say we have one issue, education,
let's say let's do it at 30 minutes.
30 minutes per person or 30 minutes total?
No, like as a max 30 minutes per person. Like even if you, let's say you have a motion here, like I think they give you like 20 minutes to talk. Like it's
Mm-hmm.
not a lot of time.
Yeah.
So you
Yeah. Yeah. I mean,
have
I
to,
think about what appellate court, we each had 20 minutes total to talk.
right?
I was
Yeah.
fine with that. I like that.
Yeah. Like
So,
it's quick, right?
yeah.
So more than half an hour, no, you wouldn't have. So you're not going to have time to go through all your binders and all your, text messages and screenshots and things like that. You have to be prepared.
Okay. What about witnesses? What if someone's like, I have a bunch of people that can talk, and yeah, I'll just put this person, like, do you take witnesses in arbitration or no?
You can. I don't think I've ever had that come up for me personally,
Mm-hmm.
but yeah, like as long as everything's transparent, the other side knows, I'm calling, I don't know, so and so as a witness, to corroborate let's say the medical. I'm calling this doctor who provided this assessment.
Oh,
But I don't
okay, so
usually
speaking, go ahead.
I haven't usually had that happen where there's witnesses in arbitration. There's been evidence, let's say, a doctor's report, right? That type of thing presented as evidence.
So it's not the same as court in a lot of places because court would be like, we need the direct testimony and we're not going to accept a doctor's note.
Yeah,
So it sounds like arbitration allows for more.
it does.
How do you handle like hearsay, like something like this person
Yeah,
told me this or
we
whatever?
don't.
Is that,
Yeah,
yeah, okay.
that's still hearsay. It doesn't matter if it's in court or in arbitration.
Yeah,
Yeah.
yeah. Oh my gosh, this is so great. What about, so anything else with the process? What about, how does someone know if it's I'm wondering if you can tell when it's time to bail. Like arbitration, I feel like that's basically like it's your mini
Yeah.
trial. What about parent coordination where uh, people just aren't getting anywhere, and it's like we've had unfortunately situations our clients have reported that they have to go to a parent coordinator, and then the parent coordinator it turns into someone just screaming about the past
Mm.
and attacking them, and they're sitting there going, why am I being subjected to this, rather than being resolution focused? To me, that's something I wouldn't want our clients to have to sit through. Like, how do you handle when somebody starts attacking another person during a parenting coordination session?
So I separate the parties, first of all. Um, I usually, so if they start with bringing up the past, I let them just like speak for a little bit. And then if it's something that continues, then I will separate the parties. We'll take a break. Sometimes we'll adjourn that day completely, depending on the case. Like if it's gotten to be an aggressive situation, yeah. So we'll just stop it for the day.
Okay, and I just have another question I thought of. Do you ever meet separately with the parties during parent coordination?
Yes. Yes.
Okay. All right. And what about in terms of like taking a neutral stance? I'm not talking about mediate when your role as a mediator, but as a parenting coordinator, because a lot of times our clients will be like, I need to talk to the parenting coordinator about the power dynamic in the relationship. Like, how do you feel about one party being like, you have to know the history of this case before you meet with us?
Yeah. I always have an intake meeting with each party separately. I hold a 1 hour intake. So that gives both parties the chance to speak about the relationship, the narrative. I think the narrative of what happened in the relationship is really important to understand the dynamics of the relationship, but also the personality of the parties involved. So,
Yeah, for
yeah,
sure.
definitely, I give both parties that hour. And then if there's something that the parties want to address with me privately, I do respect that. And then, that seems to help quite a bit. But definitely, you have to remain neutral in all cases.
Yeah. What about I keep thinking about, I have all these questions because I'm thinking about, like, I'm so glad to have you because I rarely get to talk to parenting coordinators and learn about arbitration. Uh, a number of our clients' parenting coordinators have fired them because our clients belong to the club of, this is the craziest case I've ever had. Like, parenting coordinators say it, their lawyer says it. Like, do you ever fire people, or what would cause you to fire a couple?
Um, so I usually do parenting coordination contracts for 2 years because I think 2 years is a good amount of time to be working with them, ironing out any issues that relate to the parenting plan, and as well as any issues that kind of come up along the way. So usually, like if there's been a breakdown, let's say I don't feel you're acting in good faith anymore, right?
Mm-hmm.
I'll terminate the contract. Um, like if there's like lying and deceit and things like that, I'll terminate the contract. If we're going through PC and now there's a power imbalance, let's say, that was not noted in the beginning or it's gotten worse, right? those types of things, or if we just feel that, you know what, you're not going to resolve this through PC. You're going to have to retain counsel and bring it to court.
Yeah.
So,
Yeah.
yeah, there's a few instances, I guess.
Yeah. Okay. And then what about this? This comes up all the time. When people do a parenting plan, often they don't realize the things that are going to change over
Yeah.
the years. And so some people have a clause built in that says this will be reviewed every 2 years or whatever. Would that be a good opportunity to have a parenting coordinator? And how much, and now I'm going to ask you a compound question. So is that a good idea? And then how much authority do you have to help somebody tweak their parenting plan?
So, as long as both parties are in agreement to attend mediation or PC sessions to revise the agreement,
Mhm.
then we're fine. We're back at the drawing table. We're going to talk about it and make revisions based on that. So that's not a problem. And what was the first part of your question?
Let's see. I forgot. Oh, all right. So, and what authority do you have? So let's say it change it, like people want it to be reviewed, but then if they don't agree on something,
Yeah,
and then they're battling over it and they're like, I don't want to go to court, but I want to change the parenting plan.
yeah.
How
So
much authority does a parenting coordinator have versus our arbitration? Certainly, it sounds like they could change it
yes, in
through arbitration.
arbitration, yeah, you could change it in arbitration. If there's a court order, you have to bring a motion to change
Hmm.
right to the court. So it depends on the situation.
Yeah, yeah, yeah. Okay.
Yeah,
All
it
right.
really does.
All right. Great. I mean, this has been so helpful. Is there anything that I've forgotten that you feel like people should know?
Um, you were asking me also if it's a good idea to put in the agreement like a reviewable clause. So
Oh, yeah.
usually
Right, right.
in my agreements, I usually put that it's reviewed yearly,
Mhm.
specifically because tax information here in Canada has to be submitted to the other side every year for the purposes of recalculating support.
Oh, okay. We don't have that here at all.
Oh, okay.
I mean,
So you,
sometimes, but a lot of times, like my lawyer, when I got divorced, was like, we don't want to do that.
yeah. So, I mean, you cannot put that clause in,
Mhm.
right? You could make, there's two ways. You could either do like a yearly review at tax time or upon request. So it's been 3 years and you're like, I think he's making more money. Let me exercise this right of mine at this time. But
Hmm.
usually in our agreements, there's usually something with respect to review and
Yeah,
the
yeah.
exchange of tax information.
Okay, so I'm thinking our clients, if they don't want their information reviewed, then they should keep that clause out of there.
Yeah, exactly.
All right, good to know. All right, well, Marian, can you tell people how to find you and who you're able to serve? Because I know you're in Canada.
Yeah, so I help clients right across Canada with respect to mediation and parent coordination. And then I do offer some of the services in the US as well. You can always find us at absolutedisputeresolution.com.
Okay, great. Thank you so much. I really appreciate this, and I can't wait for our community to see the recording later.
Me too. Thank you so much for having me today.
All right, take care.
Thanks, you too.
Bye.
Bye.